Okay, so now we're going to talk about, uh, and this may be the last section of this. Try to section it off because I know it's a lot of really boring stuff. But we, uh, when you have those coverages, uh, something that another reason for us to say it does maybe doesn't make sense, at least to me, to have unless there's no other option, um, in with the company on my BOP or whatever, endorsement or the coverages. And that is, um, I'm a big fan of umbrellas, although I do a little 15-minute thing and I tell you, whether it's personal or commercial umbrella, that the umbrella is is one of the words in the business that I get bemused by because the only thing this umbrella is the frame and the handle, and you have to put the coverings on the frame and the handle to keep the rain or to have keep the sun off your face. Okay, and that has to do with your underlying coverages. And I did, kind of explain that why. But uh, the deal is when you have these so-called specialty coverages and like cyber or employment practices, the umbrella does not apply to those things. Now, like I said, the other thing about the umbrella, I like it over the liquor liability that's in-house because it won't cover, an umbrella generally won't be covering if it's what we call quote unquote follow form, no such thing, but close enough. They, I want them to pick up the underlying limits relative to liquor liability and hired and non-owned auto. Okay. So, and that's part of the reason why we recommend, if possible, to have the umbrella with the same carrier, so there's no um, back and forth related to that. Um, but the situation that uh, has gotten us concerned, and this is now kind of moving into um, not so much about the insurance coverage at this point. And as you know, I said that I'll mention again Sean Smith, the vice president over there at Amwins, and watch his video and those other ones that are, insurance agents that are 6, 7 minutes long or whatever. Yeah, watch them. It's another source. Uh, I actually try to look through. I'm actually on this thing on YouTube only because the person that I work with said, I think it's a good idea that we try to share that really with everybody. And I tell people this opinion only. You always need to get a second opinion, even with my stuff and everything else. So, but here's what here's what goes on in the world of employment practices. Okay, so uh, let's say I have well, I'm going to actually kind of do a California et al. I guess call it, um, because I told people that we have franchisees out in California, and there's there's two sets of two bites at the apple here. Okay, and this applies to Texas and other states, New York, of course, Florida, New Jersey, whatever. I'm not going to go into every state. I'm a little more familiar with California and of course Texas because I'm out of Texas, but I've written 34 around states or whatever, and I'm involved in Florida and whatever. So here's where your pricking point, if you will, on this. Um, when you have somebody who has a claim about you, of course they can go over to see Dewey Cheatham and Howe, and and he can get involved. But generally, what most people do, and sometimes that may be a benefit, is they'll either go to the federal level, which is the EEOC, and relative to restaurants, they do have what they call the Youth at Work initiative, which is most of us with our sons, daughters, brothers, sisters, whatever. A lot of people, if you ever go to the restaurant, are young people, and it may be their first job. And so you have to accept the fact that they may need to have a little more scrutiny in terms of protective. I mentioned about the $8 million, um, you know, um, verdict against Chipotle, yeah, here in Texas. Okay. All right. So here's what happens. Say the person is I'm not talking about quid pro quo. We know that strict liability, one off, whatever. But let's say it's a hostile work environment, or they think they were retaliated against, or there was, something related to promotion or whatever the allegation is. Okay. So they go to the EEOC and they employment economic opportunity program, EOC, whatever you call it. Okay, so they go to EOC and they say, "Hey, I think I was discriminated against." And by the way, discrimination, as it's outlined, is not. There can be sexual discrimination, but there can be or harassment, excuse me, but there can be just regular harassment. So it doesn't mean the harassment has to be sexual. It can just be general harassment. Uh, you know, I've seen that in the workplace, and it's toxic when you got an office bully or somebody like that. Now, what happens is, in a way, the EOC may not be necessarily a bad thing, and here's the reason why. They go over to the EOC. EOC takes in their complaint online, whatever, and then they'll notify the employer within 10 days that there's been a complaint. Now, they're going to make a letter of determination, uh, but what they try to do initially is see if it can kind of be arbitrated or worked out. But if it can't be worked out, they're going to do their investigation. You, as an employer, are going to be right out in front of that and cooperating with them as fully as you can. Now, the EOC very rarely will take legal action against an employer unless it is uh, let's say, repeated, egregious, whatever you want to call it. Okay? So when you look at that, you say, okay, well, they filed a complaint. That's not good. Well, no, it's not good. But the thing is that if they're settled out at the EOC level, the average settlement is about, if something's paid out, is about $40,000. Okay. So you say, okay, that's, 40,000. All right. Now, here's where here's the rub. And it's kind of almost borderline humorous to me. It can't make sense out of nonsense. They make a if it goes through where they're going through the whole process of investigation and things haven't been worked out or resolved, they can come back and they can send the person to say, yes, we found blah 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 something going on, and we're gonna give you a letter. It's called a right to sue. Okay, but the funny part is, and you have like, I don't know, 90 days or something on there. I won't get into all the specific nuances of the process, uh, but they also have in the letter of termination, they say we didn't find any wrongdoing, blah blah blah. But the ironic part is they also say in that letter, if you ever seen the letter, it says, yeah, but if you don't agree with this, you can sue anyway. So I'm like, it's not worth the paper it's written on, because one says, you can sue, and the other one says no, and you can sue either way. However, the one that says right to sue may give some credence to uh, whoever's maybe getting involved from from the attorney standpoint. Okay, so the attorney, maybe he's the one that's coaching him and says, he's good at EPLI or whatever, and he says, let's go through the process and let's see them investigate, blah, blah, blah. And, attorneys generally ran a law firm for 2.5 years, dealt with attorneys and, whatever in that space. 98% of the time, these freaking attorneys just want to settle because they're interested in getting their 40%, or whatever they're, making on the deal. They don't want to be dragged out for years and this and that, appeals and everything else going on. Okay, so that is on the EOC side. Okay, now there's another bite at the apple. And if I was an EPLI attorney, I would be doing this as well. And that is you file with the state, okay, the state's organization. In Texas, an example is Texas Workforce Commission. Um, the California recently changed theirs to the Civil Rights Department. It used to be the Fair Employment Housing Act Administration or whatever. And they have much more onerous rules related to or conditions related to um, employment practices. In the state of California, unlike, some of these acts require certain size, 15 or 20, WARN Act, which is the Workers Retraining Act. I think it's 100 or more. The Family Leave, Medical Leave Act, I think is 50. Okay. But when you get into the state level, and I'm using California example, they start at 5. Okay. So pretty much if you open a business and you got a restaurant, you're going to have 5 employees. I don't know any business that can run these kind of organizations, even if it's just part-time people. Okay, so right off the bat, boom, they got that. The other thing is on the quid pro quo, okay, or excuse me, on the workplace, if it involves a supervisory and involves sexual harassment, it is strict liability. The Farragher-Ellery standard, okay, which I'll re-mention again, okay, uh, is that in order for you to have an affirmative defense, the only thing the Supreme Court recognized was you have a program in place, it's been communicated to the people, somebody, if they have a complaint or whatever, that they have the methodology to file, and that after they file, that there will be a response appropriately. And of course, in a small organization, if it's the owner or a supervisor, you have to make sure that they have an alternative to somebody other. I mean, I'm just joking, but if it's the husband that's the owner with the wife and the husband's the one doing it, well then you say you can report the harassment either to the husband, which ain't gonna do any good because he's the one harassing, or you do it to the wife. But a lot of times it's gonna be supervisor/owner. Okay, that's usually what it comes out to be. Okay, so and you take action on that. Well, New York is the same. It's similar. I don't get surprised. These some of these states are more aggressive in that regard, but New York, excuse me, let's go back to California. California basically says strict liability. Now they disregard the Farragher-Ellery standard. Okay, as far as the liability goes, because the liability is strict. Strict means absolute, no negligence. You did it. Guess what? But they will look at it in terms of mitigating, in terms of what we call quantum. Quantum in the legal world means damages. So it's not a total disaster that they're not looking at allowing you to have that defense. Okay. But here's where, and I try to, once again, educate and try to basically implore these these California restaurant folks, in particular, that we have dealings with, and say, you are basically uh, in a position where um, basically in a position where you are required by California law that if you have uh, a certain number of employees, that you have to have all your supervisors go through a 2 year or 2 hour online, which is free. You can get it through your um, EPLI carriers management program, risk management, which is free, that you should be using. If you're not, I don't know what to say. But California will offer you this, and the bottom line is you can go ahead and uh, have the supervisors do it, and they do it every 2 years. You'll avoid the fines. At least it shows you're trying to act in what we call good faith. Now, employees, when they're hired, California also requires you to have them do a 1 hour program within 6 months of coming on board. So new employees, whether they're supervisors or line people, they have to do it coming in the first 6 months. The what do you call it there? The supervisors, they need to do it every 2 years. So don't play with fire with California, okay? Because at the end of the day, um, it is probably the most litigious state, bar none, and it's very much in favor of defendants, okay, or plaintiffs, excuse me. And you know, there's counties in some parts that are like legal hotbeds. Orange County. The other thing you'll find on standalone EPLI, and this can be a challenge in California versus other states. Most states, when you buy the EPLI, they might have a so-called deductible or self-insured retention of like 2,500. Now, one thing I like about I'm just using, there's other carriers, Beasley, I think Houston General, whoever, whatever, um, that they will allow you to have, much higher limits. And my attitude on EPLI, you should see if you can get the sky as the limit. But be that as it may, um, if you can get those higher limits and they're still affordable to you, by all means do it. Franchise ors are now requiring, I think I'm using Wingstop example, $250,000. As a matter of fact, any franchisor that doesn't have their own EPLI and is a and then isn't or in conjunction having things named as additional insured on the EPLI, um, that's a problem, because they're going to turn around and they're going to sue the franchisor, and they're going to sue the franchisee. So you don't want to have a um, situation where in your FDD or your contract that you say, I'm covering you for employment practices and whatever, and it turns out you don't have adequate defense coverage or the limits, if you will, for coming in there. And and then I'm going to tell you this last little thing, and this involved a California franchisee. And the interesting part was the person who was involved in this case, the franchisee, very nice people. But what happened with them was um, a complaint was filed, and of course, in this case, suit was filed. And they said, we didn't do anything wrong. And they were said, but, hey, I was talking to the insured and I said, and she really appreciated talking to me because I'd worked in a law office. I knew where she'd come from. I knew how upset she was about everything. And I said, let me just tell you this. I said, this particular situation that you've got, you know, we're gonna the company is gonna try to do whatever they can, obviously to protect you, but because the defense costs are within inside limits, I said the problem with this is that your limits, particularly when you've got the franchisor listed as an additional insured, that the problem you've got there is that that money, um, most likely, and at that time, they only had $100,000 that the franchisor required. But once they got their nose bloodied, they wised up and they told their franchisees, at least in California, we want 250, okay, minimum. Okay, so they go and they get, well, they didn't have 250. But what happened was this case turned out to be whatever. It didn't go into some super, you know, stratosphere type of reptile nuclear verdict type of claim or whatever. But what happened was the the ownership, the franchise ownership, uh, got their own attorney, and their attorney was high dollar attorney, and as far as I'm concerned, was a waste of money to the tune of about $50,000, which was upset the franchisor, and I'm on the franchisee side, but the franchisor, and it got to the point that our attorney that was representing our franchisee, Claudia Olivetti, with a very large international firm, it wasn't some small fry firm, and she was able because the franchisor was upset. The finance guy that was over there, and I told him, I said, "Well, look, I know you're owned by the Rourke, and they hired DLA Piper or whatever, and as far as I'm concerned, was a giant waste of money because they didn't even do anything other than show up for the hearing and deposition, so they didn't even, um, handle the case." But fortunately, Claudia was able to go to DLA Piper and get the 50,000, negotiate down to 25,000, was still too much. But everybody was pretty upset about it. But I said, well, first off, you know, there is a provision in the policy that states about um, who handles the claim relative to the lawsuit. And the lawsuit, as a general rule, larger companies maybe have people in house or specialists they work with, but the smaller companies, my opinion is, these franchises dealing with, you should use um, they can call them panel counsel, but I would recommend using the insurance company's recommended counsel because these guys are special gals, are specialized, and Claudia Alvetti was very nice, and then of course the insurance company when the claim turns around and non-renews. And so, the insured, the franchisee is upset, and right, as far as I'm concerned, rightfully so. The insurance companies cancel them because they had a claim, which basically, in my opinion, based on what I know about it, was much to do about nothing, but it rang up uh, exorbitant legal fees, because you have to defend yourself. And that's one other thing. When I mentioned earlier about um, the when you're looking at the um, EEOC, uh, the average claim I think I mentioned may settle out for 40,000. If you go down the route uh, of litigation and Most of them get settled, 90 something percent, but that could involve hundreds of thousands of dollars, and the verdicts, as evidenced by the Chipotle deal or whatever, can run in the millions. And once again, you have to realize that 70%, according to Insurance News, just read this article, of the businesses out here are dealing with an employment practices situation. Okay. And 30% of all lawsuits in the United States are related to employment practices. So I don't think it's a question of if it's going to happen to you. I think it's a question of when it's going to happen to you. And you need to be fully prepared. Legal structuring can be of value separating out. I wouldn't have all my eggs. I wouldn't do the Titanic strategy where I put all my legal entities and then the water goes over the top to the next chamber and the next chamber and then the boat breaks. So that, even though that's not a like the insurance, looking at it, because remember I said at the beginning, insurance is not a uh, not a transference. It is a financing, and it's subject to the coverages, policy limits, this and that. So if you sign a contract, whether it's with a franchisor or anybody else for that matter, it's called privity of contract. It's personal. It's between you and that other person. And the question will become, I'm just saying this, that um, they, the insurance contract is not connected to any other contract that you may be signing. Okay. So I think I've pretty much covered everything for now. You know my feelings and thoughts and opinions. I do say to you that the Sean Smith thing, I think, really as a primer, at the very least, anybody, I don't care if you're agent or insured or whatever, or your business owner, take the 26 minutes out of your life and watch that, and that'll give you a handle on the thing. It'll talk about third party. You know, I'm pretty outspoken about not liking defense within limits. Uh, there's things that I, obviously favor. I've made clear what those are. And of course, if you have any questions or anything, my door is always open. You can ask me anything. I don't care if you're another agent or, an insured or whatever. Because I'm just here to, not be an original thinker, just to give you the information. So, okay, so this pretty much takes care of, I kind of broke it up so that you could, how do you eat an elephant one bite at a time? And the EPLI is a big elephant. So, but, you know, uh, just try to do just a couple things. Uh, that'll help some. Okay, thank you.